In the previous video, we looked at the different sort of proxies that the court can potentially use when faced with a transfer to an unincorporated association. And in this video, I want to explore the question of which proxy will the court use when faced with such a transfer. So if you haven't seen that previous video, I would check that out first because this video very much leads on from that one. But let's get into it now. So the court's approach differs depending on whether a transfer is one made by way of performance of a contractual obligation or voluntary. And contractual transfers include money transferred in exchange for a raffle ticket, association membership, entry to an association fundraiser, and so on. So when an unincorporated association sells something to the transferor, such as a raffle ticket or membership to the association, the transferor is contractually obligated to transfer money to the association at the price of what they have bought. So if you transfer £1 to an unincorporated association in return for a raffle ticket, you are transferring this money by way of performing your contractual obligation. Voluntary transfers comprise collection box donations, inter vivos gifts, and legacies. So transfers to an unincorporated association can be entirely voluntary. So you can have collection boxes or donations or under your will. So there are two different transfers, two different types of transfers to an unincorporated association. You can have a contractual transfer or a voluntary transfer. And the judge's approach to the question of proxy depends on the transfer before them. So it will depend on whether the transfer is contractual or voluntary. So firstly, the contractual obligation. When money is transferred by way of performance of a contractual obligation, it is invariably treated as a gift to the association's members subject to the association's contract. And we have this quote here from Gardner. Money is often paid to a club not voluntarily but under a contract between the payer and, say, the club's treasurer. This is the case, for example, with members' subscriptions, raffles, and entertainment. The player here is buying something, say membership, the chance for a prize, fun, and paying the money as demanded by the contract in return. And the contract under which the money is paid simply gives the payer no choice of paying it on trust, only of paying it absolutely. Say I want to buy a 50p raffle ticket from the club treasurer. The contract of sale will require me to pay the 50p absolutely. Say I suggest that instead I settle the 50p on trust for the club's purposes. The treasurer will reply, no deal. So the position when the transfer is contractual is fairly straightforward. It will always be treated as a gift to the association's members subject to the association's contract. Okay, it will be the second proxy, as explained in the previous video, the court will follow. Okay, the contract holding theory. Now, why is this? Well, the third and fourth proxies are simply not available when money is transferred pursuant to a contract. This is because when a transfer is made under contract to an association, the contract will demand the money be paid over absolutely. Okay, so when property is transferred under contract, it does not permit the property to be settled on a purpose trust. And this is explained by Gardner in this quote. I would recommend that you read the article. The article is called New Angles on Unincorporated Associations if you're interested. So the first two proxies each involve an absolute transfer of property, but of the two, the contract holding theory is clearly the more appropriate as it is closer matched to the transferor's intentions. So, for example, if I buy a raffle ticket sold to me by Oxford Cricket Club, I would sure intend that money to be added to the association's funds rather than divided between the members for them to spend as they wish. So the first two proxies both appear available, but the second is clearly preferable as it is a closer match to the intention of the transferor who is transferring under a contract. And then we've got the voluntary transfer. Okay, so when money is transferred voluntarily, okay, my residual estate to the Camberwell Social Club, all four proxies are in principle available. So what is the position then when money is transferred voluntarily? Well, when money is transferred voluntarily, then all four proxies will be available. So although this should be caveated by saying that if the Camberwell Social Club is not operating for exclusively charitable purposes, then of course proxy 3 won't be available. A judge will select the proxy which best reflects the transferor's intention. So, for example, if the testator who leaves the residuary estate to the Camberwell Social Club was a long-standing member of the club with a great personal affection to the other members, a judge may well conclude the best proxy is the first proxy, in other words, a gift to the members in their personal capacity. Okay, a preference for the contract holding theory. The case law reveals a strong judicial preference for the contract holding theory as a proxy for voluntary transfer. So often, however, when money is simply given to an unincorporated association, there is no or little evidence for a transferor's underlying intent. So the choice of proxy is guided substantially by judicial preference. In reality, there is a lot of judicial discretion as to the choice of the proxy, and in the exercise of this discretion, judges have a very strong preference for using the contract holding theory as the proxy for voluntary transfer to an unincorporated association. So, crucially, the law is very reluctant to use the purpose trust proxies. Now, there are a number of reasons for this. Okay, so firstly, best match for transfer intent. So, in the absence of any real evidence as to the intention underlying a transfer to an unincorporated association, the contract holding theory seems to be the proxy which best reflects the intention which we can suppose the transferor held in making the transfer. Okay, so recall that under the contract holding theory, property transferred is held by the members of the association subject to the association's rules. The association's members can then vary or terminate the contract between them, and so apply the transferred money in new ways as time goes on. Conversely, under either purpose trust analysis, the property transferred is tied to the purposes, whether they are charitable or non-charitable at the time of transfer. So transfer of property on the purpose trust analysis then cannot be applied in new ways with the passing of time. So the idea then is that an individual who voluntarily gives money to an unincorporated association wants their money to be applied to the various purposes of the association as they develop and vary over time. They don't want their money to simply be applied for the association's current purposes. So it is for this reason then that the contract holding theory is legitimately seen as closer to the wishes of someone who makes a voluntary transfer to an unincorporated association. The second reason is ease of accounting. Now, we know that some unincorporated associations' income will arrive contractually, as this money will be held on the contract holding theory, as I explained a moment ago. So it makes for easier accounting to take all income on this basis. So whilst money taken voluntarily could in theory be held on purpose trust, it makes life easier for everyone if the court rules that it is held on the same basis as money which is paid pursuant to contractual obligation. The third reason is rejection of the Reed-Denley purpose trust. So the third and perhaps most interesting reason is rejection of the Reed-Denley purpose trust. So as mentioned, maybe only in passing in the previous videos, some judges, especially those wedded to the beneficiary principle, do not accept the authority of Reed-Denley. So for example, Lord Millet in Twin Sectra and Yardley. So most academics and judges don't accept a purpose trust can be valid simply because there are individuals tangibly interested in its performance. These people believe that outside the exceptions posed by charitable trust and some non-charitable miscellaneous ones, it is impossible to create a purpose trust. In other words, they don't believe in Reed-Denley and they consider it bad law. So some people, or some judges, simply do not consider the fourth proxy to exist and is therefore not available at all. They feel there is no such thing as a Reed-Denley purpose trust. So obviously, these judges are going to tend towards the contract holding theory. They do not view the Reed-Denley trust or the Reed-Denley proxy as a legitimate proxy. They do not view it as a legitimate substitute for the transfer of property to an unincorporated association. And finally, we've got relative simplicity on dissolution. Okay, so the fourth reason underlying the judicial preference for the contract holding theory is the relative simplicity on dissolution. And I'm going to explore this in a bit more detail in the next video, but in brief, money held on the contract holding theory is easier to deal with in the event of a dissolution than in money held on purpose trust. Okay, and dissolution is just when the association comes to an end. So if the association comes to an end, it is easier to deal with surplus funds which are held on the contract holding theory than it is to deal with surplus funds that are held on purpose trust. Okay, so I'm going to talk about that in a lot more depth in the next video. So yeah, in broad brush terms, money under the contract holding theory is divided equally between members, whereas the purpose trust money is returned to the transfer on a resulting trust, which of course is going to have practical difficulties. Now, note there are cases in which the courts have used the re Denley proxy though, such as in re West Sussex Constabulary Trusts from 1971. So, more often than not, the court will use the contract holding theory, but in some cases, they will use other proxies, okay? Such as in this case where the court used the re Denley proxy. This case involved the West Sussex Constabulary, which is a unincorporated association, and derived revenue from various sources, including collection boxes, donations, legacies, etc. It was held that these voluntary payments were held on trust for the West Sussex Constabulary's non-charitable purpose of granting allowances to widows and dependents of deceased members. So the proxy used was a re Denley non-charitable purpose trust. Ostensible purpose trust valid as a contract holding gift. So we know then from what has been said so far that legal proxies are intended to operate only in the context of a transfer that is made to an unincorporated association without further instruction. For example, where money is transferred to the Camberwell Social Club. We know that it is because the association doesn't have legal personality that it cannot hold property in its own right. So the proxy is the vehicle that circumvents this issue. Where property is transferred for a stipulated purpose, so for example to Camberwell Social Club to paint their club room, recourse to proxy seems unnecessary. So we would imagine then, when property is transferred not simply to an unincorporated association, but to an association in order to fulfill a particular purpose, that there is no problem with giving legal effect to the transferor's intent as expressed. For example, by providing the society's treasurer is to hold the property on trust as trustee for the purpose specified. So where property is transferred to Camberwell Social Club in order to paint their club room, it seems we do not have to rely on a proxy. The proxies bite when we have to have a simple transfer to an unincorporated association without further instruction. But when we instead have a transfer to an unincorporated association for a particular purpose, we would imagine the law would just give effect to the transferor's wish by establishing a trust under which the property must be used for the purpose specified. And of course, some judges would be prepared to do that, such as in the case of re West Sussex Constabulary. So if faced with this particular or this kind of transfer, a transfer to a unincorporated association for a particular purpose, many judges would hold as valid a re Denley purpose trust. Yet ostensible re Denley purpose trusts are frequently reinterpreted as outright transfers, for example to Camberwell Social Club, so a proxy is required after all. So recall though, not all judges accept the authority of re Denley. Not all judges think it's possible to establish a purpose trust for a non-charitable purpose, with the exceptions of miscellaneous non-charitable purpose trusts. So how would judges treat such transfers to an unincorporated association for a particular purpose? Some judges, when dealing with something that looks like a re Denley purpose trust, as here, would hold the trust invalid. Okay, but more often, these anti-re Denley judges, when faced with something trying to be a re Denley purpose trust, will instead reinterpret the ostensible purpose trust as an absolute transfer, treating the purpose as the motive for which the transfer was made. For example, some judges, when faced with a transfer of money to the Camberwell Social Club to paint the club room, would treat that as an absolute transfer to the Camberwell Social Club, and consider the reference to painting the club room as an indication of the motive underlying the outright transfer. So the transfer then, of course, becomes one to the unincorporated association without further instruction. And this, of course, takes us back to the legal problem which confronted us before about before, meaning that a proxy must be employed after all. Okay, of course, the judge doesn't believe in Reed Denley, but interprets the ostensible purpose trust as an outright transfer to the social club, will obviously not then select the Reed Denley proxy. So the proxy they will invariably select is the contract holding theory. Okay, so often then we get judges who interpret something that looks like the Reed Denley purpose trust being transferred under the contract holding theory proxy. This chain of reasoning, of course, will only be done by a judge who does not believe in the Reed Denley purpose trust. And the exact effect of this line of reasoning is seen in these two cases here of Re Lipinski and Re Hawley Town Football Club from 2006. So in this first case, money bequeathed to the Hull Judeans Association to be used solely in constructing new buildings held valid as a contract holding gift. So in this case, money was given to an unincorporated association to be used solely in constructing new buildings. So this looks like it could be a purpose trust. In other words, money to be used and to be settled for the particular purpose to construct a new building. But the judges didn't hold this as a valid Reed Denley purpose trust because they didn't believe such a thing could exist. So instead, the transfer was reinterpreted as a straightforward outright transfer to the unincorporated association, which threw up legal problems that it is impossible to do that as the unincorporated association lacks personality, therefore engaging the need for a proxy to give effect to the transfer. And the proxy selected was, of course, the contract holding theory. And in Re Hawley Town Football Club, freehold land settled on trust for the primary purpose of securing a permanent ground for the Hawley Football Club held valid as a contract holding gift. So this again looks like a purpose trust, but it was not held valid as a Reed Denley purpose trust as the judges didn't believe in them. So instead, they relied on the contract holding theory. The outcome would probably have been different if the judge in Re West Sussex Constabulary had been hearing the case, and he would have likely just said there was a Reed Denley purpose trust here. But of course, not all judges are the same, and some are instead going to rely on a different proxy, in this case, the contract holding theory. Okay, I hope I explained that okay. I think that could have been a bit tricky for some people, so as per usual, please do leave any questions below if I haven't explained something very well. It's a bit difficult to explain it on the fly, so if you have any questions or any problems, then please do let me know and I'll try to clarify any of the points I made. But as usual, if you enjoyed the video, then please give it a thumbs up and subscribe to my channel. Thank you very much for watching.